Any the following before you stated here A, B, C, D, E, etc., etc. So it's not personalized on his own term, but the term enshrined in the bill is that the term you go with. And so then you had a passport. If I don't have a birth certificate or I don't have this, I should not register. No, I can produce anything. Somebody can come to identify you. Everything is clear about it. So I mean, I don't know. It's not that you are not registered. Anyone before you can be given for registration.
Mr. Chairman, even though we have not reached here yet, but let me take your attention to clause 25. No, wait. I am justifying something. I am linking 24 to 25 and see the implication of the words in certifying himself. Mr. Chairman, we all are aware of the fact that even though we are not discussing the issue about NCRA here, for now it will take you more than 2 weeks if you want to get a birth certificate, to get NIN number at NCRA. It will take you more than 2 weeks. More than 2 weeks. And you see, Mr. Speaker, that is why Mr. Chairman, I have a lot of respect for you because of certain statements you made few days ago. That not under your watch, that even an apostrophe or a comma can be altered in the ground law, not under your watch. And we like that. That's why I chat in a lot of respect to you. And so on. And please. You know nothing about parliament. Mr. Speaker.
No, I don't want any controversy. All of you know a lot about parliament, that's why you are here.
Mr. Chairman, no, he doesn't. He satisfied himself.
Mr. Chairman, point of order.
I've already said what
He should withdraw. He should withdraw. He should withdraw. He should withdraw. I will not sit down.
Stand
You
up.
have nothing. You know nothing about parliament. You know nothing. I will not until you withdraw. I will not. You are not an accountant doctor. You are from Waterloo to Dominion. You have nothing to tell me. Yes, withdraw yourself.
Honorable members, I rule that each and every one of you have a lot and you know a lot about parliament. By definition, you are members of parliament, so you know a lot.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. So, Mr. Speaker, the word in satisfying itself should be expunged because we are dealing with a process.
Can I draw your attention to section 25 of the extant?
Yes, Mr. Speaker,
apart from the NIN issue, which is also mentioned there, look at section 25 of the extant law and tell me what essential difference there is, apart from the NIN.
Mr. Speaker, Mr. Chairman, I think a few hours ago you talked about making corrections. We should not be only relying on what has passed. You understand? We are here now to do what is needful. And the needful in this circumstance is to ensure that to satisfy himself has no place here.
So what is your proposal?
I say it is a process. So I will rephrase it. A registration officer may satisfy the process and not satisfy himself.
Who is in charge of the process?
No, the process is quite different to the individual. I am fully aware of the fact that the arms and legs of institutions are human beings. But these human beings have been guided by procedures. And
Who applies the procedure? Who applies the procedure?
The human beings. And you cannot say in satisfying yourself. If I do not satisfy myself, this is a law. You cannot personalize a process to be personal until you satisfy yourself. No?
But what if it is clearly it is to satisfy yourself? It's not left without clear criteria that he should use in reaching a decision. He has to satisfy himself about certain the existence of certain conditions.
That is very subjective. It is subjective, sir.
Mr. Chairman. Mr. Chairman.
Clearly stated.
Mr. Chairman. Mr. Chairman, the honorable member from Bombali is speaking about the registration officer having satisfied himself. And he made reference to 25. And 25 is very clear, saying that if he is not satisfied with the person, he has to do that in writing and sign. And the person has also the right to challenge. So if his assertions are not correct, then there is a challenge to it. So I see no reason why this was there. There is a challenge to it. It's not just open-ended like that. It's also giving the person the chance to challenge whether once the registration of there is wrong. It is there, 25 years and B. That's
Mr.
Chairman, can I still
Mr. Chairman,
I'm still on my leg. I'm not doing it.
But I was talking and you
Mr. Chairman, please, with your permission, can I still
it's better we adapt the clause of the instant law than we use this one. When we use 25(1) of the instant law, it is better. It is far more better than 25(1).
Even though there is a safeguard,
but you repeat,
even though there is a safeguard, the safeguard that should be challenged. No, it compares to make a written report about his decision. And that written report is subject to challenge by you, the registrar.
We have to look at the time, the exchange of time, Mr. Chairman. Mr. Chairman, and the circumstance at that time.
Mr. Chairman, may I be heard? It's going to be very brief. The provision there is very standard. And sometimes we find ourselves having to deal with this provision. It's like, for example, when you apply for a visa, you have the immigration officer or somebody from the consular services. It talks about satisfaction as he may deem fit. Doesn't mean it's going to be personalized. It's based on the process that are clearly stated. So here we are talking about any of the following. For example, where you talk about, you understand, he's going to give due consideration. Somebody might present a birth certificate. He will have to look at the authenticity of that birth certificate. Then he has to satisfy to some point. So in the case where somebody is rejected based on a fake birth certificate, then that particular reason for rejection is going to be clearly stated. So I think it is a standard clause, but again, it's going to follow the processes that are out there. So it's not going to be personalized. I rest my case, Mr. Chairman.
Yes, Mr. Chair. Mr. Chairman, from the back, please.
Yes, Chairman.
Yes.
Still on 24, as stated,
Stalin.
registration officer may, in satisfying himself that a person is entitled to be registered as a voter, request from the person any of the following, any, not all of the following, while pinpointing on the NIN as a qualification to vote. So that is it. So if there is no NIN and there is a birth certificate, that person is entitled to vote. Now let me say, Mr. Chairman and Mr. In the just concluded by-elections, the information of the registrants or the voters are indicated in the
So you are point of order. This one is register. You need to correct that from
I would have gone on that amendment that the safeguards that are arbitrary decisions being taken by the
we are talking about safeguards. For the preceding clause, that is clause 13.
We've already stopped the bill
But I'm making a point.
with the veto coming back.
Yes, because I just have to take the when you talk about safeguards. The clause 13, which is mandatory, will be migrated from clause 13 to clause 24. It will be. And that is why I am saying, even though you are talking about safeguards, the issue of himself has a problem. It should not be himself. For the process, if I do not satisfy myself, I will not, then I will advantage the individual. I think no. To register.
The disadvantage
Yes, I will disadvantage the individual.
arbitrarily because that the remedy provided for him.
What is the remedy?
Well, you read your documents.
What is the remedy,
It is clearly indicated. Read what
there is no remedy in the words satisfying himself. There is no remedy in words satisfying himself.
Let us assume you took an arbitrary decision. You think that's the end of it? Is that your understanding of that clause?
You are telling me about taking another step further. But that will not, and that's why I quoted the issue of timing.
Mr. Chairman.
That's why I quoted the issue of timing.
If you read 25.
Mr. Chairman.
Mr. Chairman, I beg to see principle of natural justice. Applies in this case. Principle of natural justice. If that now, it's not the safeguard. Even in the court, you have the right to appeal. So don't proceed, please.
In a society wherein we have high illiteracy rates, in a society where we have high illiteracy rates, and also accessibility is a problem. That is where you are telling me you go to safeguards to be addressed in a court of law. When even accessibility is a problem, even some of these democratic institutions are now more political than they should appear.
So why are you representing illiterate people here? Mr. Chairman.
Chairman, that's why the issue here is to say,
I'm going to progress.
yeah, no, but
I'm going to progress.
yeah, but let us progress. We are going to progress.
I'm sure the rest of your colleagues understand this.
I do.
Well, I'm not so convinced that you are. That's why I keep asking you to read all of it. Don't just split those words to satisfy yourself and make a mountain out of a molehill.
Okay, well, let me.
Yes,
Well, read in your quiet moment and try to digest it.
No, I want to read for the edification of God. I'm not in my quiet moment.
Yes,
I am not here to read in my quiet moment, but to read and
Chairman.
meditate.
Well, I cannot allow you to do it.
But
You can come back to your concern if you want. But I have to make progress.
Mr. Chairman,
Yes,
please.
Chairman.
Mr. Chairman.
Yes.
Mr. Chairman.
Yeah.
I want to believe this should not be an issue. To me, I am comfortable in that they say any of the following. Right? I am for the good old things. In 25 of the 2012, you have 25C, the testimony of a member of the local council in the area. Right? You have the same thing in the new bill. So I see no reason why we should delay this. Because if we say the local people are not, the local classes are not important, that's where the law will come. Right? But there is not here. They are not asking for anything in particular, any of this. So I think let us accept it that way and go ahead.
Yes, Chairman.
Thank you very much, Honorable Member. A great chef, yes.
Thank you. I've been struggling to make a contribution. I am more particular with clause 25B and clause 26, where the
25 what?
25B, 25B.
We're on page 15. Yeah, no, we're on page 15.
We are saying
We're on page 15. Page 15. It's not to 16.
when you reach there,
Mr. Chairman. Page 15. Mr. Chairman, clause 22B. Maybe the AG might want to help us with this. Clause 22B. Clause 22 deals with the Electoral Commission may from time to time, by its statutory instruments, make orders. When you go to B, it talks about specifying a date for the publication of notices, inviting eligible voters to present themselves for registration in the ward in respect of which the notice is published under section 25. But 23, sorry. But no, my lenses are failing on. But an order already in existence, if issued not more than 2 years earlier, shall be sufficient for the purpose of this section. I wanted to plead with the AG to reduce this to 1 year. Because 2 years in a 5-year election cycle is a very long period. People would have forgotten 2 years down the line. So I want us to consider reducing it to 1 year. 22B.
And then I'll invite the AG.
the AG, because
If he wants to comment on that one to do so, we can proceed.
because 2 years might be a long time.
Mr. Speaker, Mr. Chairman, honorable members, this is all the more reason for Section 31 of the Constitution as we envisage in clause 13.1, 1A, Roman figure 1 of the Constitution. Mr. Speaker, the substratum of this one is to avoid the issue of every year or every election period we spend a lot of money again to register and regard the whole electoral vote. But the point is, Mr. Chairman, the issue for 22.1b for it to be reduced from 2 years to 1 year is noted and will consider that in due course, Mr. Chair, why should progress?
And also, let me draw the attention of the House that I see no difference between the extant law
and this one. Yes, exactly. Me too. Because I looked at them. But where the AG came from is totally different from where I came from. I'm talking about 22. No, not between Kube. 22B, and he is talking about 13.1. They're not connected in any way. Even with the civil register, in future, you might need to do it on a monthly basis, maybe not every 2 years. So that's why I'm saying, if notices, because you're talking about notices, but if it, not the registration itself, the notices, renewal of notices. If he thinks 2 years is comfortable, so I'm fine and good. Yeah, if it is good for him, fine and good.
Mr. Chair, let me just throw a light and show the connection between 13.1 and 22. Mr. Chair, 13.1, if the NIN is captured at every registration, there is no need for us to go over the registration list periodically, because automatically it will generate itself and renew the process as we go on. This one, as is stated here, Mr. Chair, is so elaborate, but should the name come into play, automatically it renews itself and upgrades itself as we go on. This will reduce all the labor and the unnecessary ventures and expenditures the state will undertake as we progress towards every election period. There is a nexus.
Wait. Mr. Chairman, it seems as if the AG is confusing itself. Even in the most sophisticated democracies, whether it's in the US or in the UK, voter registration is updated. Not
really.
That is it. So he has to know that. So it's not.
So it's the period that is.
That exactly. That is the point I.
I was just trying to draw the line to let them understand the link.
They are not.
The link between 13.1 and this particular provision is
They are not.
Basic state.
They are not.
Basic state. Let me listen to the chief.
Thank you, sir. Chairman. Mr. Chairman, on 2015,
This will be done electronically. It will be done electronically as we progress.
Yes, it does.
okay, because I would have brought the proposal for the state.
Yeah.
Okay, so I only wrote that a registration officer may be certifying that a person is entitled to be registered as a voter. The request from the person, any of the
No, you are now reformulating.
yes,
No, it's not necessary.
it's okay now.
Mr. Chairman.
Yes, Mr. Chairman.
Mr. Chairman, sir.
Chairman, please. What page?
I want to bring you to page 12, please.
What? No, Mr. Chairman. Chairman, please.
Page 15, Mr. Chairman.
No, I'm not going to. Let me say
No, that was arbitrary. No, we are not
Page 17.
Chairman, 16.
Page 16, 16 years.
And 15, please, Mr. Chairman, before that, sir. Very important, sir. 15.
Yes, the extant act says, let me just read the provision. Section 22.
Plus
No, I'm referring to the 2012 Act.
Okay.
It says, upon notification by the Electoral Commission, the President may. And what the bill is proposing now on 22, it says the Electoral Commission may. What's the rationale for the removal of the President in the announcement of dates of those benefits? Can you please justify? We know, but we know NEC has already been independent, but the announcement of the presidential dates has already been done by the President on the advice of the Electoral Commission. So, all I want, can you please explain? In the 2012 Act, it says that the President is going to announce on the recommendation of the Electoral Commission. Why are they now just saying that the Electoral Commission without the involvement of the President?
Mr. Chairman. Mr. Chairman.
The President used to be council of those
Mr. Chairman. Can I be that on you?
Yes, AJ.
Mr. Chairman, honorable members, the reason for this is simple. We're here to pilot this bill to ask this House to empower the Electoral Commission of Sierra Leone, and we want to remove the presidency from that announcing election date. Mr. Chair, this also will take away so much power the president will have in determining election dates. We want to make Electoral Commission of Sierra Leone very independent. As I was here again asking this House to amend and repeal 32.2 and 32.8. So particularly so for 32.8 to replace the word misbehavior to cause misconduct position and be able to carry out their duties without any fear or favor. So also is a rationale for this, that we want to make the Electoral Commission of Sierra Leone very independent. So no one individual in his mind as president will determine when we go to election or will hold us to ransom as to determine our election date. The rationale is to empower NEC to determine election date away from the presidency.
So you widening the scope of independence.
Right, sir.
Mr. Chairman, if that's reasoning, I don't know why is it not moving that the appointment of the electoral commissioners being taken from the president. Because that's what. So yes, if you really want them to be independent, like Kenya is doing. Even when Kenya appoints, they have to be subjected to public scrutiny. The public should be involved in the appointment. So, no, it's not. It's not. We have seen commissioners being appointed here without consultation being put apart. If you care about the independence of this commission, then that's the way to go. No.
Like this is.
We are representing the public, and I reference my previous points. And it reads, where a registration officer refuses to register a person, the registration officer shall advise him accordingly and make a written record of any statement which the person may wish to make in response to that advice. You know, words in a statute must be clear and they must free from repugnance. They must be consistent. You know what I'm talking about? Yes. My view, this chart I shall make the very specific. It is about disqualifying people not to register. No way. That's the main point. If you refuse somebody not to vote, he has no capacity to register. And you have not made a proviso. You have not made a proviso. If he is so disqualified, what is the remedy? Say for instance, I want you to that. When I speak from an informed place.
Are you talking to me or
Thank you, sir. Mr. Speaker, my worries to that is somebody can say, well, I intend to disqualify ABCD people in this fact. We saw what happened in the MCRA, where in some areas people are not allowed to register. They took false machines.
No.
So now we want in this bill to be referenced if somebody has been verified. Somebody might claim that your birth certificate is not correct. And if proving correct, then what is the remedy? You are not giving us the advice for in this bill if somebody has been proven valid. For any reason, somebody will say your birth certificate is not legible, and later you have to give a report.
Mr. Speaker, I observe a certain member of parliament constantly on his legs whilst abusing his mind for other tools. Look, I'm telling you, constantly giving others. It's not a distraction with this guy. He's always sitting down now because I've raised the issue.
The whole government is
Yes, let me continue. You and I know, members of Parliament know the rationale behind this bill. And now critical it stands, even for ourselves being members of Parliament, from either side.
What do you understand that?
And I read, the words are very clear, Mr. Speaker. They are very simple, and you know further interpretation, except that you want to invite some interpreters for. It states that where a registration officer refuses to register a person, the registration officer shall advise him accordingly and make a written record of any statement which the person may wish to make in response of that advice. My point is there. For any reason, as we are, somebody may tend to say, okay, in the strongholds of the opposition, we will use some means to disqualify somebody. I make reference to law. There is always a presumption in law, and that presumption is always immutable. I want to inform people to know that the law, there is always a presumption in law, Mr. Speaker, and it can be removed. You know very well, and I know.
Mr. Chairman, can I just step in, please?
So let me finish my point. I am expecting a remedy to that very clause. If somebody has proven that, what has come to everything there. It is not good, it is fair, and it should not be fair. I don't think it should be fair.
The remedy is now.
Where are we sexual?
Continue reading.
25.
Continue reading.
The electoral commission shall be given 40 days after that 25
Chairman 16, 17, 16, sir. 16. Yeah. 16. Okay. Here's 26-1.
I told you, but it's
But I have a different view of what my colleague was saying.
You will accept yourself.
The side notes of 26-1, records of statements made by persons refused registration. This is very, very important here. I want to move that it goes beyond this one, where the person refused registration and the highlights of all the reasons stated. I think there should be a third party to this, where the person has been denied registration. So maybe somebody may tend to challenge this one to remedy it through the court. And that's what I'm saying, the record. But if you are writing, keeping the record, then the person denies. There should be a third party to ascertain that this happened. The appeal, what is the reference? If there is no third party, and the person denies. Now that's my understanding.
Mr. Chairman, 16.
Well, except if you say so, but I think there should be a reference by a third party. Except if we all agree on that, but the written record, a third party to that, I think is important.
Mr. Chairman,
I think I want to subscribe to the view of the honorable member. It is very important. You know, these are critical issues. It is very important that, because this is the form of attestation. In law, we always consider attestation that I as a witness attest that so and so should take place. So it's important that we incorporate that.
What is the essence of the written record?
Okay, for the sake of ascertaining or
What is
verifying
the
that.
essence of
No,
the written record?
no, but the point we have is, Mr. Chairman, it can be a situation in the witness, there should be a witness to attest that yes, this person entered this record. The role of a witness is different from the person who is taking down the record, Mr. Chairman.
Mr. Chairman. Mr. Chairman. Yeah, I think
there is a point on the floor. We are waiting for.
Yeah, it's still on the same point. Yeah, Mr. Chairman, on this, there's always a third party to this under this refusal, because if you go to 24, you have proof of claim for registration, and under C, if you go to 24C, the testimony of a member of the local council in the area of his residence. So if somebody has been refused by the registration officer not to register this person, I think this there's always somebody in the community who can attest that this person has been ABC criteria as stated in the bill. No. Yes. No, it is here. Well, yeah, it is here. It is expressly stated here. The third party is expressly stated, Mr. Chair. If you go back to 24 to plus 24C, I think it's expressly stated. That clarifies the
Mr. Chairman, that is not my submission. The statement of records, there should be a third party to that statement. That's what I'm saying. Not what is stated already.
Hold on, Honorable. I know you put on your mind because every sound you are making is clearly audible. And it's very clear to me that you just come from north. And I know what you consume during lunch.
So, Mr. Speaker, I take exception to that statement. I only took okra. So, please, sir.
Do yourself a favor.
I will do myself a favor, sir, if only you can allow me to make a little bit of contribution to this argument. I'm also a member of parliament, sir.
You are a member of parliament.
So you do not wish me to speak?
There is a presumption that a member of parliament, when they walk into this well, are in a state of mind.
I am quite correct to say to you, sir, I am in a state of mind to say whatever I want to say, sir. So if you can allow me, sir.
I will not allow you. I will not allow you.
Mr. Speaker,
We are always doing this.
no, Mr. Speaker, please. Okay, he just want to make contribution to the debate like any other.
Deputy, please.
Mr. Speaker.
No. Not in that state.
Oh, he doesn't. Yeah, we've done enough for the longest time.
Page 18, Mr. Speaker. Page 18, Mr. Speaker.
Thank you very much.
Page 18. Yes. Mr. Speaker, I have compared old law, the existing law, and this bill. I noticed that under section 30, under the procedure to omission and objection, 30 subsection 4 in the Act state that
page 18 now.
Yes, page 18.
Mr. Chairman, we are still on a point raised by the honourable member.
We are here to 16.
Yes, Mr. Speaker. Chairman, sir.
Mr. Speaker.
Okay, I'll wait for the
Mr. Speaker, the submission I made for 26-1, the statement of records, I still insist, because this is law. In the event that somebody take the court to redress his refusal,
to register. A third party might be required here. That's what I'm saying. Notwithstanding the written record. Yes, notwithstanding.
You still want a third party?
Yes, on the written landed attorney. Can I hear? Okay.
Mr. Speaker, honorable members, I think it's a valid point to consider that, Mr. Speaker.
No, he says he will consider that it's a valid point. He will come back to us.
Mr. Speaker, page 18. Mr. Speaker, page 18.
Hold on. Yes.
Page 17, Mr. Chair. Page 17 plus 27 plus 2.
Yes.
It says the 40 days period referred to under subsection 1 may be extended. Then there is the word thereof. I said it should be 4.
Yes.
For a period not more than
That is correct.
15 days.
Correct. Thank you.
Mr. Chairman, page 27 as well. 27,
Page 18. Page 18.
page 17, page 17. Under clause 28. A, it should be a point.
Yes, thank you.
Page 18, Mr. Speaker.
That's a typo. Now let's go to 18.
Yes, I noticed that a clause, a section in the current act was deliberately omitted in this new bill. And let me read the section that was deliberately omitted. That is subsection 4.
Can we say it was omitted?
Yes, omitted, it was omitted. Subsection 4 of section 30. It says,
draw the attention to the
of the bill, of the act, sorry.
law of the extant law.
Yes, sir. Subsection 4 of section 30.
Section 30.
Yes.
And the old, in the instant law.
Yes. It says a person who knowingly causes his name to be included in the copy of a provisional list while not entitled to be registered, or a registration officer who knowingly includes the name of a person who is not entitled to be registered commits an offence and is liable to summary conviction and a fine of 500,000 euros or to imprisonment for a term of 2 years. That is not in dispute, sir. And that also gives way for people to illegally register people who are not entitled to be registered.
Mr. Chairman, my understanding of the bill before us is to repeal and replace. So to say deliberately,
Forget about the
Forget about the word deliberate.
I said that important clause is not on this bill.
AG, can you please explain the omission?
Mr. Chairman, honorable member, honorable Tabo, the point is very valid. That particular provision has been taken over to the electoral offences. We've shifted it to the electoral offences. It's still part of the bill, but it's under the electoral offences. Which clause, sir?
Page 61.
Mr. Chair, honorable members, I will call your attention to page 61 under the rubric electoral offences, clause 114A.
Offenses relating to registration. A, B, C. It is A and F. Look at F. Knowingly give false information. Mr. Chairman, let's move on.
Under the rubric electoral offences, page 61.
Yes.
There are rules of them of the offences for any electoral malpractice.
Page 19. Page 19, 20.
21.
21. 22. 23.
Mr. Chairman, please.
Yes.
30.
Clause what?
Clause 39.
Yes.
The transfer of registered voters. 39(3). Now, where the registration officer is satisfied with the applicant's application, the transfer of the applicant's name, and so in addition to
read on.
To another register of voter, it shall be done within now within the time frame. Mr. Chairman, my concern here is I want that we add before the pronouncement of any by-election date, because we have seen elections in which the margin for by-elections. I've seen elections in which the margin for the result tends to be very, very minimal or meager. Now, if there is a by-election and the date had already been pronounced, now there is possibility that political parties will move voters to a particular. Then if you go to the B is talking of 21 days date receipt of the application. It's still talking about A. B is talking about A. General. B is talking about the general presidential election. Now, the B part says 21 days from the date of the receipt of the application in the case of by-election. That's the B part. Now, this is my concern, because Mr. Chairman, there was a situation in 2012 in Bo District. I know a constituency from which a particular political parties, they were moving almost all over Bo to register in that particular constituency because the particular political party wanted that seat. Now, if it is a by-election and a pronouncement has been made, what I want us to include here is, if somebody has to transfer a vote, let it be before the pronouncement of any by-election. But peradventure, there is an announcement of a by-election, particularly if it is like, for instance, Freetown here. People can move, say, from Calbaton to register at Eastern Police. They can do that one, and they say they have been relocated. And there will be an influx of a voting population. Now, how significant will it be if the person relocating is not registered to vote for that by-election? But if it is before the pronouncement of a by-election date, I will not have any issue with it. But if the transfer of votes precedes the pronouncement of the by-election date, some other political parties may take advantage of it. Thank you.
Mr. Chairman. Mr. Chairman. Mr. Chairman.
On the same issue?
Yes, sir.
Yeah.
In addition to what he has said, 3A and B, I would prefer the votes can be transferred during the period of general elections. And once those votes have been transferred during that period, those who have transferred, even in the by-elections, for as he rightly said, transferring votes to the pronouncement of by-elections, it's possible that they can move voters from one constituency to the other to transfer their vote because of the period the time has been announced. So what we are saying, we delete B and stick to general elections. Once that vote is transferred before general elections, we go by that, but not by elections. It can be fraudulent, it can be problematic, it can allow a lot of
AD,
that's my submission.
on the same issue?
On this same issue.
Yeah.
I don't want to subscribe to the honorable member's submission. There are circumstances where people register, for example, in Freetown, but my birth district is Pujon district. Let's say my political party decides to award me a symbol, which means I have to transfer that vote to that.
We are talking about by elections. I am very specific here. We are not talking about general elections. I am talking about by elections. Transfer votes is the process of by elections. It's not correct. It can be chaotic. It can allow election malpractices and fraud.
Have some circumstances where people register, for example, in Freetown, and the circumstance vacancy occurs. My party decides to give me a symbol, let's say in my birth district. I may decide to transfer my vote. I do believe it is my right also to transfer my vote. I'm not
First of all, the transfer of votes is predicated on residence. That is what you people are missing. So go back to the very beginning of clause 36. Is when you are resident in one ward and you moving residence to another ward. I don't want you to begin to read the subsections in isolation.
Yes, sir. But Mr. Chairman, now when you are doing the application for the transfer of your vote, you are engaging the registration officer. All he or she may ask for is any information to authenticate your transfer. They will not go to your house to check. All you can produce is just documents. These are the concerns. That let it stay for national election. But for by-election, Mr. Chairman, the transfer will be very, very insignificant to impact the outcome of the result.
Mr. Chairman, if we go back, like you said, if we come back to 39.2, the sub-transfer of registered voters. 2, where the registration officer is satisfied that the applicant under section 1 is qualified for registration and is ordinarily resident. This is the operative word, ordinarily resident in the ward in relation to which the application is made. Ordinary resident. And when it comes to page 24B, 21 days, as in this, 21 days from the date of receipt of the application in the area of a by-election. So it should be an ordinary resident and in the case of by-election. So it's 21 days and the ordinary resident, let's take that into account, the word ordinary resident. It's not permanently resident. Yeah, it's